Well, that was awful. And I'm really sorry about that. I cannot tell you. That has never happened to me before, ever. I have never done that before. And I just feel terrible about it. So I am so sorry that my email was shared. And I don't even know, because I didn't even look whose it was. And I think it might have been from the Hales. I'm not sure. But I did reach out to them to apologize for that. I have never done that before. Oh, lesson learned. God, that was awful. All right, let's get back to the hearing. Let's see who's here. Hey, MG.
Hey. Oh, that was fun.
That has never happened to me before, ever. What I feel like a moron. What an idiot I am.
I did it on my stream one night. I was having audio issues, and I pulled up my Windows settings, and I was sharing the entire screen for like a game or something, and it popped up on that screen instead of one of my other monitors, and it had my full name up there. I was like,
Homestead Dream says it was
private it, cut it out.
Homestead Dream says it was too blurry to read. I tried because I'm nosy. Well, I hope to God that that's true, because if somebody screenshotted it, that would be really bad. And I hope that didn't happen. And if you did happen to screenshot it because you were just feeling curious, would you please delete it for me? Because we're talking about sources that do not need to be outed that are in my inbox. And that really upset me. So I apologize, but dang. All right. I want to share this. We have to go back to Judge DeThomasis in the third hearing. Let's just play this again. Let's put this back on. And I will go through and edit that out later and put it back up, so that you guys can, those of you who were, behind. Teresa says, I paused at that time for a phone call and it wasn't readable. Well, thank God. Well, thank God. I hope that that's true. I hope it wasn't readable for everybody.
Hopefully nobody was like watching it in 1080p.
Right? I mean, there wasn't anything like that, but I mean, I just don't, that was terrible. And I'll never do that again. Lesson learned. Now I know that I cannot share the screen there. I have to download the thing, and because that was just a total mistake.
Yep, I've been very careful with my settings window since then.
Terrible, right? Just terrible. Okay, we were at 44 something. I can't believe we were only 44 minutes into this shitty thing.
Tailoring the language.
Hey, Valhalla.
If you go back to the transcript of 12:6, and I'll literally tell you in just a few minutes here. I think it was at 55 minutes and 27 seconds through about 58 minutes, and I'll get to the exact reading of it.
55 minutes and 27 seconds.
What kind of autistic brain would you have to be able to pinpoint a random second in time?
He does that.
He's so bizarre.
So bizarre. This guy is so weird.
Literally said those words.
You did, and you also said there's been no opinion on. There's been no opinion.
Narrowly tailor it so that's not to infringe upon his constitutional rights.
Totally agree.
And I gotta say, I read the language for which counsel said no objection. I then took a break. I then wrote it out. I then came back and read it, what I had previously orally pronounced, and again, counsel said no objection. So
orally
doesn't mean it's not unconstitutional.
And I'm not.
What other kind of pronunciation is there aside from orally?
Read, Bud Love, whatever the case.
Oh no, am I frozen? Did it freeze?
Not for me. Well, the video stopped.
The court video did, yeah.
Oh, I know why. Okay, let's see. Cancel that. All right, I'll make it start again. Ready? Here we go. It doesn't like my change setup. Maybe that's the problem. Let's try that again. It didn't like my new setup. Okay. remove, add
All right, we are.
40.
Yeah, which goes back to the old statute. Yeah. No, I think the opinion is great. I think it's
Behalf, Mike, and I'm not saying there's no reason for you not to have read Bud Love, whatever, the case from 4 days ago,
Yeah.
opinion, to now advance a different argument or a more concise, articulated argument based on that ruling. You got every intent to do so. I understand that from your motion. You have every opportunity to do so. We're going to get to that.
okay. And the way we said that there's no opinion on it, so the way we get that is just go on Lexis and just do a flag if any of this statute ever gets, that's how it got so quickly, I flagged
That's
it.
what I'm saying. It's
Yeah.
no surprise to me.
No, I think the opinion is great. I think it's an amazing clarification. But it tells you how judges, even the two up there, have two separate basis for ruling.
And
I'm sure this judge doesn't like that ruling.
Certification of a conflict with the prior David decision that's in part of the concurrence of the chief judge.
Yeah, which goes back to the old statute. Yeah,
I got you.
Yeah, okay.
I'm there. I was there. I was there 25 days before the opinion was issued in my oral pronouncement.
And the reason
My oral pronouncement.
Such a stupid
Bye.
Oral
It's
pronouncement.
it's within the realm of tailoring. It's not a blanket gag order. You didn't order him to take down videos. There's no book burning, digital book burnings going on. It was. But I think this opinion does. We'll get to it, but I think it does really make it
I
clear.
got you.
Okay.
So back to the
So
timing of this. I want you to take into consideration, and with sensitivity to and understanding of other.
Also, I'm really sorry to those of you who sent super chats that I didn't get to. I didn't get to read them, and I'm really sorry. And I don't think I can pull them up.
Conflicts and calendaring, but it's not going to necessitate or dictate the results of a separately considered issue, which is,
Okay.
does the injunctive relief stay in place, and if so, to what extent, if any, is it modified?
Thank you, Judge. So I would just say, like I said before, we can get these. We have to make sure she doesn't have any, that she's available too. But I really am jammed until Martin Luther King Day. After that, I can move around depots. I'll move heaven and earth to get it done this month, starting from the 16th onward.
All right.
I'll move things.
So I also have to take into consideration, without even asking, for instance, I'm not going to have you take the depot and say, okay, we'll see you at 2 hours later or the next day. You might have to digest it and decide, does the deposition require you to go, oh, she named 2 other people I need to talk to, or whatever.
And also on that point, that, your point is well taken. We're going to treat pro se litigants the same way as a reasonably competent attorney. At her depot, she's going to be asked, do you want to read or waive? And if she
Right.
said, so that could cause 30 days delay if she says, I want to read my transcript.
There's no doubt that if the depot took place on 12/21, which it didn't, we would have been here, I think, ready to go on January 4.
I would.
Even if you had to hustle over what would have otherwise been people's holiday. That being said, it would be the court's intent to give you additional time after the time in which I'm going to compel the depot on a date. I want to get that done straight. So there's no disagreement or misunderstanding. Clear the decks for the depot.
Do you though?
Plus,
Do you want to get
fill
it
in the
done?
blank days
Because
for us to
you
come
now
back to
ordered
hearing.
them not to do it, I
And I
believe.
can tell you, I can cancel things
Really?
and change things, but I can
Well-
provide-
Well, I
can
think he
make
threw out the one they did, and he's only going to give them a certain amount of time to do another one. It seems like that's what that. Of course, they're not going to do it now that's on hold.
I don't know if he threw out the one they had, but he wouldn't listen to
I
it in
think-
court. He
How
would
would
not
he-
let them play it in court
Yeah.
because he got pissed off that it was online, that some of it, a portion of it was posted on YouTube.
Yeah.
He thinks that somehow that's not allowed, that
Yeah.
Jeremy wasn't allowed to post that on YouTube, which I don't
Hey.
know of.
He was. I mean, it's not a move that I would make, but he paid for the transcript. Paid for
Yeah,
the
he
depot.
paid for it. He
It's-
paid for it. It was his.
You know, you normally don't want to put your discovery out there, but there's nothing confidential contained in what he released. So I don't see why he would get in trouble for it. The judge got more upset because they didn't have the videographer's name on it, which they didn't know until they sat down for the depot.
Yeah, he called it not a properly noticed
Which-
deposition.
Yeah,
But that's
which was
ridiculous.
waived as soon as she
They
sat.
waived
As soon
it.
as she,
It's- Right.
Yeah.
As soon as they sat for it, they waived it. Oh, I just realized I need to send out a notice on Twitter that I have a new link. I'll go do that.
You're saying, so when you say Martin Luther King Day, some people work on that day, some people don't. The
No,
court observes that as a court holiday. But that's the 15th. If you can get the depo, you tell me what date subsequent to that, I would offer you.
Oh, thank God. I apologized to Jeremy and George, and they got my email, and they were like, it's okay. There was nothing that sensitive in it. It's okay. Everything's all good. They're not upset with me. God, I feel awful. Believe
me, I've been there with my own information, and I'm like, oh God.
God, and there were like 2,500 people watching?
Yes,
Oh.
yes.
If we can stipulate now that the transcript doesn't
We
need 30
acted
days
fairly
for her
quick.
to read it, we can do that.
If there's a oral motion to advance the time frame in which to review and read
They're
for
making an
purposes,
oral attendance right now.
that would be granted. The only question is then to what extent, okay? So
Well, I'll rush the transcript.
depo on what day?
I would like to do the 16th.
So, and again, I'm
And for
not,
Cook, probably the next day on the 17th.
so Cook and Preston, it would be your intent?
Yes.
So Ms. Preston, because you have a right to be present during Mr. Cook's, you've got an obligation to be present for you as the petitioner.
And it could go either way, either orders. It doesn't matter who goes.
Either order, but right. So January 16, 1/6, and 17, 1/7, can you and will you agree to be present?
Yes,
Yes?
yes.
Okay.
Now I'm asking the court not to drop the temporary order. What the court doesn't realize is going
I'm gonna get to
on.
that. We're gonna get to that. I'm gonna
Sounds
hear
like,
from you on that. I presume you're gonna.
Princess
object.
Leia and her
So
bounty
I'm
hunter.
gonna give you a chance to be heard on that, but let's get the calendaring of this. Do you know who the court reported, you're gonna issue subpoena to Mr. Cook, you're gonna notice?
Well, he didn't appear. He's under subpoena already.
Right. So it would be continued subpoena to, let's just go, who's gonna be the 16th, who's gonna be the 17th? Or are they both,
I would like her to go on the 16th.
Ms.
And-
Preston on the
yes.
17th, on the 16th?
On the 16th, and then let's say he can start at, we'll do his at 11 a.m. I don't think I'm going to need all day for him, so 11 a.m. on the 17th. Hers beginning in the morning,
9 a.m.?
9 a.m.
Sir, can we do that at like 10? I have a
That's fine.
special needs daughter.
Okay.
I am so sorry, but my child at 8
Hang on, you don't have to give a
a.m.
reason if there's an agreement to it. and it
fine.
sounds
Oh
like
God,
there's no
I think the
And we're doing
bingo
it by
card.
Zoom.
We've
So
probably
it's-
had
But
bingo
my
several
child
times.
takes medication in a feeding tube at 8 a.m. I need time to
Oh,
give her
The kid
medication.
has a
No,
feeding
Councilman,
tube
you
and
can tell.
running
Feeding
around
tube?
running around in conditions like that on that property.
Wait a minute, a feeding tube?
How the hell do they keep it clean?
When did
That's
this
an-
happen?
That's an open wound.
She
That's-
was touching a turtle and then handling her daughter without washing her hands in the video we watched.
Oh my God.
Dean in Florida, what can you show the follow-up video after a ruling so we can see what really happened? What follow-up video after a ruling? I don't know what you mean by that. These are the only videos that I have are the court videos. So it's like the entire court. There is no follow. I don't know what you mean by follow-up video. There's the court hearings, and I'm playing each one every day so that we get caught up on what happened exactly in court. But I'm not sure what you mean by that. Dawn Wittenhagen, thank you. Says, I made you a bingo card and posted it on locals. Okay, I'm going in there now. I have to reopen Windows and stuff. I shut down everything because I got panicked.
And somebody asked about the new federal lawsuit that Jeremy's filed. I have a copy of that petition. So they have filed a federal suit. He has filed a federal suit in the Northern District of Florida against Lynette and Junka.
Oh, really? For what?
Yes, it was filed yesterday. I haven't gone through it. It was sent to me last night. I have it off of Pacer. I got the PDF and images of it. So.
Oh, great.
I'll be reading that tonight.
Excellent. So MG Law is going to read the new lawsuit against Lynette. This is Lynette's Turtletopia Meanwhile, in Turtle Purgatory, thank you, locals. Thank you, locals, for keeping it funny. What else do we have? I'm looking for the bingo card. Apparently, there was a bingo card on locals. Where is it? It must be further up. Let's see. Can you, locals, can you just repost the bingo link? Because I'm not seeing it. Where is it? Oh, there it is. Wait. Nope. Nope. That's not it. That one? All right. I don't see it. So somebody give me the link again, because I don't see it. It's not in the chat where I'm seeing it. I don't know if my chat's not loading or what exactly, but it's
January
not
16,
working.
petitioner's deposition, 10 a.m. via Zoom. Counsel for the respondent will get that all set up for you. You'll get the notice and the hookup for that. Mr. Cook would be considered a continuation of the subpoena already previously served for 12.
What the Hales is in chat. He says, yes, we are suing Lynette
suing-
Crook in federal court for extortion and defamation.
At 11 a.m.
Awesome.
Ooh, interesting. Jeremy, do you guys want to come in here? I can send you a link if you're not busy, and talk about it if you want to. I'll send it in in email, which I will not be sharing with the stream. Fuck's sake.
Oh, fun times.
I'm not going to recover from that for a while. I may have
Believe me,
PTSD.
you will, because I do it every time now I open something. I was like, oh, crap. Trying to open up settings and hope that it's not on the wrong screen.
I'm seriously, I've never done that before. I have literally never shared a screen I didn't intend to share, ever. So I feel like I'm going into shock. If I start turning white,
it, so
I did.
That's the good thing.
And I'm going to take it down later, and I'm going to edit it, and then I'll put it back up. So if you were behind and you wanted to catch up, don't worry, it'll be back up later. But I need time. I need time to do that. So just give me.
To find mine. Yep.
Yeah, give me time on that. I sent a link to Jeremy in case he wants to jump in.
He says in chat, unfortunately, we aren't able to join. We're listening while we work instead of whistling.
While we work. Well, it's good to see that you are you're alive and well, and nothing bad has happened, and at least nothing dire has happened at this point. And I definitely want to see this new lawsuit. I think maybe somebody just sent it to me too. I
they
believe
may have.
I got
it from 2 different people last night. So.
I got something in from Justia. Is that Hustia or Justia? I never know how to say it.
Was it the website?
Yeah.
I think it's Justia.
Yeah, I'm not a Pacer member, so I probably can't access it. But MG, maybe you'll send it to me later.
I will. I'm going to send it to you, and I got to send it to Jeff as well.
All right.
He was like, "Where are you getting this?" I was like, "Well, the Hales viewers, the fans sent it to me, and it's a federal lawsuit. I got it's file stamped."
Damn! I lost a wall off the shit shack. Jeremy, did you see? Jeremy and George, did you see the shit shack I've been working on? We're working on building a Lego Turtle Purgatory, and currently I have the shit shack is under construction. I've got a bunch of stuff I pulled out for like a dead rotting fish that we might, I don't know, just throw in there somewhere. And then there's random dangerous tools like an axe that we can have like floating around in here somewhere. Like there's an axe, and I'm going to put some glass all over on the ground and some like nails and stuff. I have some sharp edges here. Here's some sharp edges that poor little girl can, might scratch herself on because there's like nails sticking out from things. Let's see, we'll put it here. What am I doing? Here we go. These are actually dinosaur teeth, but look, they're real sharp. I can't see them real well there. Let's try here instead. There we go. Now we got it. See, little sharp teethy edges. And and like random tools that shouldn't be around, like just kind of hanging out. I'm going to find some way to make it look like a junkyard. I made this like little trash can thing that I was going to put out here and maybe put a fish hanging out of it. But the problem is that I can't find a piece to attach it. So I've got to find an attaching piece. But anyway, this is the shit shack with the bucket and the or sorry, was it shit shack or shit shed? I can't remember what we were going to call it.
Shit shack.
The shit shack. Yeah. Sorry, Megan, that is too neat and clean. Oh, well, yeah, tarps. I do need tarps. I'm going to have to find some tarps. Lego does
Your turtle
not,
sanctuary.
yeah, Lego doesn't give tarps, so we're not able to use a Lego sanctioned tarp, but I will find some fabric around here somewhere.
Commencing at 11 a.m.
By Zoom.
January 17 via Zoom as well.
Yeah.
Ms. Preston, you have an obligation to appear on January 16 at 10 a.m. You
That's
have
fine.
It's fun.
But nobody's going to make you.
Ability
No one's
to-
going to
Right.
put you in contempt if you don't.
At the depot to commence 11 a.m. the following day of Mr. Cook.
That's fine.
Thank you, James.
Okay.
And what was the day you wanted to have the hearing then? Friday, the 26th?
Would they issue a bench warrant in a civil case like this?
Not as
Okay,
much
so
as
if we
want.
can, I can
No,
get the.
for a deposition, probably not.
No, you'd hold them in contempt if they didn't appear for the hearing on contempt. Then he certainly would issue a bench warrant.
Oh, you would?
Oh, if you have a citation for
if you didn't
contempt
appear-
and they
no,
don't,
if you don't appear at the hearing, they'd issue a bench
yeah,
warrant.
that's what I'm saying. At that point, you would issue a bench warrant and have the deputies drag your ass in.
Right. Yeah, that they would do.
Transcript, rush ordered, and if we can give her, if she wants to read, maybe she can correct it by, but see, here's the problem, Judge, if she changes her testimony by an errata sheet, we have to then inquire as to the basis of that.
We have to cross that bridge if we get to
Okay,
it.
so, yeah, I'll
And
get
if-
it.
And if need be, not that I'm inviting this, but if that happens, that may be something that you have to reach out.
Well, you know what, Megan? I've decided that I need to go buy
And
a
ask for
bucket
expedited,
of loose Lego
hearing.
now
Meaning
because
that-
I don't have enough pieces to make this work.
Here, we're gonna come to a date.
Really? I have so many Legos. My husband apparently, I didn't know this about my husband, but he's an addict. Him and my son are addicts, and we have so many.
Didn't know it.
No, we have so. I didn't know it. I mean, I knew they had a ton of Legos, and I was always like, why do the Legos take up the entire dining room table? And it's like, now I'm in heaven though, now that I'm into it, because I'm like, holy crap, I've got enough Legos to make several worlds,
Awesome.
That is awesome.
Oh, locals, right. I didn't post the new link in locals. IT Goatee Brad, are you out there? Can you do that, or do I have to do it? I'll do it. I'll go do it, because IT Goatee is probably working.
By which it needs to be read by, if there's an errata sheet or there's some reason for redeposing or whatever, clarifying, whatever needs to happen, we might be able to also still save the January 26th date by this court somehow finding time to address, even after hours, whatever issue
Understood.
might come up. So if we get to that bridge, we'll cross it at that point.
26 works,
The 26th?
yes.
Oh shit, I just broke the shit shack.
Oh no.
That-
Looks more realistic
I
that
mean,
way.
it's probably more authentic now.
And every time I break it, I'm going to put it back together in a different way.
There you go.
Come back to,
Can it be 10?
The new filing is in your
Get my
email.
little Stuff done.
Ooh.
the problem with that is I don't know how long.
Thank you, Lady Tammy.
I've already made a finding
Okay.
that
Can
we
we just
needed
do
more
it to
than,
9:30
we
at
needed more
least?
than 15 minutes to conclude the proceeding back on
Right.
November 29. I
That's
don't
because
know.
of
Good
you.
Lord,
15 minutes.
jackass.
And
15
a
minutes.
full workday.
It was 15 minutes to cross-examine her.
Let me ask Mr. Shockey. And I don't know that you can answer this without the deposition first, which is,
He just hears words and
If we
then puts
keep getting
them
new
together.
filings, it's going to, new areas of inquiry, that's why it's going to be all day, I believe.
right, okay.
Yeah.
So, Ms. Preston, you'll have 22 days, and I'm not insensitive to your needs and your kids, certainly, but you've got 3 weeks to try to make arrangements.
There is no
26th.
babysitters, there's no nothing for my child. I do
You got
not
it.
let John cook, he sits outside with her.
I got you.
What?
We can't because of her illness. We cannot let anyone else near her because a fever can kill her.
Oh,
But we
so
can
full of
subject
shit.
her. We can subject her to all the salmonella and the chicken shit and the other stuff
Yeah.
that the turtle, like whatever diseases the turtles are,
The rusty ass nails.
rusty nails, so she can get. You get a fever when you get
Tetanus.
an
Yeah, you
infection
get
from a
tetanus.
nail. Tetanus can kill you too. The
Salmonella
hell?
would give you a fever.
Lockjaw. Yeah, salmonella mess you up.
Oh
For
yeah.
fuck's sake, this is so crazy. This is so nuts.
So we don't do that. It's fine. I'll just, again, have to,
We've got to be here.
Try and make
at
it work.
9 a.m. Because we may be very well faced with the situation like we were on November 29 and not being able to conclude.
Yeah.
And this court's going to do everything it can to avoid that. And quite frankly, it's going to have to be presented on that day and resolved on that day. So 9 a.m., January 26th, courtroom 1A, Levy County Courthouse, to conclude these proceedings.
Thanks, Judge. And we're trying to accommodate her. That's why by Zoom. I understand the situation
I got
to the
you.
extent I
Yeah,
feel
Zoom
that
don't
was a
help when I'm
mistake.
trying to tube feed my child and give her medicine.
That was a mistake.
She has a feeding tube, a mixed
Yeah.
button to feed and tube
Have her in
medication
person.
in. She sees her medication that has
Yeah,
to be
big
taken
mistake
at
to do
8
it by
and 8.
Zoom.
Okay.
It's,
I've heard, I don't know if you think I
I know, it's
have,
fine. I
like,
got it. I'll deal with it.
disregarded or disagreed or found what you're saying is
No.
not being credible. I'm accepting that.
I know.
I think counsel's accepted that. But given that, and despite that, that hour time frame
It's
being
fine.
chopped out of that day on a Friday on the 26th, and what's happened previously in the history of this case, we've got
What,
to, I've got to insist we start at 9 a.m.
Have an hour
We
and
got to be ready to go.
55 minutes of it as judge
And quite
pontificate.
frankly, although it's editorial comment because it's unnecessary, but nonetheless, if the deposition took place on 12/21, we wouldn't be in this situation. And if it took place on 12/21, I could then push counsel to say, now that you've taken depositions, you tell me reasonably how long it's going to take to try this case. And I can't force that answer because his answer is going to be, I don't know
I
until I
was
take the
not
deposition,
subpoenaed.
and that's understood.
All I wanted to do was say goodbye to my mom. That's all.
But
Again,
she's not dead,
we
right?
this court hasn't disregarded that or not accepted that, and I don't think counsel has. But it's created a situation that we now are trying to remedy,
Rich, which also one he did created
which is
something for
creating
me.
some
and-
pressures. So the one piece about Depo, 16th and 17th, transcript to be provided and read by in anticipation of the January 26th evidentiary hearing.
The 23rd?
So, Ms. Preston, basically, there's going to be a process at the end of the deposition. You're going to be told that you have an opportunity, if you wish, it's up to the deponent, to read the transcript, or you can waive doing so. If you say, no, I want to read it, what counsel is suggesting, and it seems pretty reasonable, that the transcript will then be typed up, and by January 23rd, if you choose to read, that you will have done so by that date. And can you do so?
That's fine.
So you'll have a week.
Can we apply the same standard to Mr. Cook's deposition?
Mr. Cook's depo of the 17th, likewise, since your party presented, present at the deposition of Mr. Cook, likewise, you could review that. She can't really do an errata sheet for that, but you'll have a chance to review it, but likewise, the same time frame by
It's fine.
January, and to be specific, by January
Tarp.
23rd, 5 p.m.
I need pieces of tarp.
Thank you, Judge. And there's one thing about that. We're still on the motion to compel?
Yes, sir.
Okay, so knowing that pro se litigants are held to the same standard, the court, you have discretion, it doesn't say shall, but this delay, creative expense, creative attorney's fees, I understand what's going on here, but I'm here to request fees based on the violation of not showing up, not setting a protective order and creating the delay, granting the motion to compel discovery and granting entitlement to fees. And while I'm on that point, respectfully, Judge, even-handed justice here. We want the same parties, the same scales, the right hands and the left hand should act equally. So this requirement in this case for the parties to prove the basis for requesting continuances was held here. I asked that she produce proof of this doctor's appointment. When was it made? Was it made? When was it canceled? Did she really have to go out of town? Just proof.
Yes, I
And
do, and I provided
an email
proof to
from
the
her
court.
sister is not proof.
Then I'll get it from, the hospital was supposed to send me something, and she didn't send it to me, but I will get with her today and get that immediately.
Okay, so let me just say, under appropriate circumstances, under the rules of procedure, rules of civil procedure, counsel, under certain circumstances, can, on behalf of their client, seek compensation for fees and or costs expended for depositions that didn't take place. Now, there's a bunch of requirements to establish, but given that there's such a request, and given that there appears to be, based on your representations, your ability to establish why you were not where you were supposed to be, kind of thing, and clearly that's relevant to this court's consideration of whether to impose those costs and or fees, I'm going to take the request for fees for non-appearance at the 12/21 deposition under advisement. I'm going to reserve ruling on that. It's going to be subject to directing Ms. Preston for you to provide by January 23rd proof and or whatever form of corroboration you have that you had a medical appointment. It does not have to disclose what would otherwise be protected medical information, but a doctor's office confirming that, yes,
I had an
Preston
appointment and I had to
appeared for
cancel
that
it.
appointment on this day at that time.
Right, and I had to cancel it that day too, to go to Naples to my mom.
Okay,
They
you
will
can
send
provide
Some
proof from the doctor's
documents
office.
that she was hospitalized and
Yeah.
Yeah,
And
some
from the
kind of
hospital-
proof.
And from the hospital
You gotta
that your mother was
go look
there.
at
You don't have to
gas
give
in
conditions.
Naples to
I mean,
come back,
he can
or
order that.
whatever you have that you think is form of corroboration. And what counsel is saying, and
I will get
I
something from
found
the patient liaison.
incomplete at best compliance or non-compliance, I think is what I said on December 6th, about the whole issue with Mr. Hales going to Ohio. You've raised that in one of your affidavits that I'm not adjudicating also. Same requirement, you gotta provide corroboration to explain why you did or did not have the ability to attend the depot on 12/21. That will in part help determine whether or not fees and costs are assessed for the non-appearance of the depot.
Right, plus the fact that I called the clerk of court the minute he called me, the minute,
I've got you, okay.
so.
So counsel, to the extent
Okay,
that
thank you, Judge.
that covers it, the oral pronouncement of this court is the ruling and it is reflected in this record. Chronologically, just to complete the matters that are otherwise been filed up and through this date, the next matter, which has already been resolved by order of the court, was respondent's motion to disqualify, filed Thursday, 12/21 at 6 p.m., which is effectively Friday, 12/22, which is, as a matter of course, the day before a 3-day court closure because of the holiday, previously of record as a court closure. The court ruled, as the rule requires, 2.330 on 12/26/23, order denying, so that matter has been adjudicated and resolved. The next matter chronologically is styled as petitioner's petition by affidavit for violation of injunction filed 12/29/23. That matter, as I mentioned with regards to other similar matters, the affidavit for alleged violation under Florida Statute 784-0487 is currently under the purview and obligation of the Office of the State Attorney to review and determine how to proceed. So there's no need for court judicial labor at this point on that matter. There may be at some later date. The next numbered issue is, or I guess filing, was respondent's notice of supplemental authority, which is a motion to modify the extended temporary injunction and a request for judicial notice of case precedent involving a ruling previously commented upon by this court and by counsel, issued 12/29/23 by the Second District Court of Appeals. We're gonna address that here in a minute because of the continuance of the evidentiary portion of this matter to January 26th. But let me address two other matters just for this record so it's complete. The remaining two matters that were filings between setting this hearing and this hearing date today included Petitioner's additional affidavit alleging a violation of injunction filed 1/2/24, again pursuant to statute 784-0487. That's within the state attorney's purview at this point. Subsequent to that, January 3rd, 2024, petitioner's affidavit for alleged violation, again, is within the state attorney's review at this point under 784-0487. I believe that addresses all matters that were filings. I hesitate to say, but it's worth saying that between now and January 26th, if there are additional filings, it would be the court's hope that none of them are designed to delay the resolution of this matter on January 26th, and that we could otherwise have this matter resolved. With regards to any affidavits for violation, the protocol, the 30-day time frame for the state to review.
Can somebody send me the link to the GoFundMe in my email box? I will post it at the top of the chat, but I'm looking for it and I don't seem to have it. So
Did I send it to you in Twitter?
I don't know.
I don't recall.
Like on a DM?
Yeah, maybe. That's where it would have been. I know I think I sent it to Jeff this
Oh,
week.
yeah. I got it. Okay. I will pin it. All right, guys. So there is a GoFundMe for Jeremy Hales and his legal fees. He's $80,000 in the whole, out $80,000 already for all of this. Now he's filing another lawsuit. I mean, this is going to be a long road for him. I mean, it's going to be very expensive. And if you guys feel like you want to donate to that cause, you can do so. I pinned it to the top of the chat. There's a GoFundMe, and he has given permission to share that. So there you go.
Is also a
6 to 8
Oh,
months.
sorry. I muted you because of your Lego noise.
My bad. Sorry.
That's okay. I forget to do it too. And I'm like, and people are like, can you stop that?
My bad. The judge has already told him that it's going to take 6 to 8 months at least, right? And for those that don't know, 6 to 8 months worth of court fees is not going to be cheap in the slightest. It's going to be just tens of thousands of dollars, I would assume, at the bare minimum.
Oh, at least. Look at my tarp.
At least.
Do you like my tarp?
Oh, that's good.
I've added a tarp.
That's good.
Yeah. There's a corner tarp, and then I'll put another tarp over here somewhere when I get that built up a little bit more. All right, here we go.
To review those kinds of allegations. Those are going to follow their own time frame and path. With regards to this court's intent to resolve the evidentiary matters before the court to be adjudicated on or about January 26th, that should occur. So what that leaves us with, let me get to it in a second, is what Respondents' Counsel filed, which is on 12/29/23 at 4:24 p.m. What's entitled Notice of Supplemental Authority, that authority being the Budlove decision, which is cited at 49 Florida Law Weekly D50A, a second DCA opinion issued 12/29.
That's a
I
fun
didn't say it 4 days
citation.
ago, but when I read it, it was 4 days ago,
Right.
6 days ago now.
Florida Law Weekly.
That the
The
court
the
obviously-
motion filed the same day as the opinion.
I'm sorry?
The motion was filed the same day the opinion was published.
I got you.
12/29.
The court's received and reviewed that. Obviously, judicial notice is taken of case precedent. It includes a motion to amend the extended temporary injunction, primarily addressing the language of the addendum, and a request to take judicial notice. So to the extent request judicial notice is granted, the notice of supplemental authority doesn't need to be granted or denied. The court has knowledge of that opinion. With regards to extending or modifying the extended injunction, let me say the following. So the the Second District Court of Appeals on December 29, as I said before, was of no great surprise to this court, and in fact, from this court's perspective, mirrors quite a bit of what the court discussed of record.
This is funny.
On
Wait, hold on.
12/6/23.
Richard Hillard says, Megan, when the shit shack is complete, auction it off to the highest bidder, like what the Hales does every Sunday night on his live. I mean, I could, but then I wouldn't have a record of all my fun Lego stories. I don't know if I want to let go of it. I mean, this is precious right here. I don't know. And then I would also have to super glue everything down
Yes, you
because
would. Yeah.
how would it make it,
Ship.
through the mail, right?
Bubble
That
wrap.
would be difficult.
It would be very difficult, but I like the way you think. I respect the grift, and that might be something that I think about later. But boy, I'm going to have to learn how to cement Legos in place then. Because that's a good idea. I know the tanning bed. I know, I can't let these things go though. I love it so much. I love them so much. And look, I started putting some greenery around the tanning salon. Wait, don't wreck the camera, Megan. All right. So I started putting I was going to put potted plants. See, I've got a potted plant here. And the outside of and I also have to create a sign, and I still haven't done that yet. I have a place for it, but unfortunately I stuck it on the back of the building, which doesn't really do me much good. So I may have to redo something up here so that I can put a sign up front. So I'll probably put a different piece up here that I can attach things to the front. But anyway, I don't know if I could let go of them. They're so funny, and I'm enjoying them so much. I'm enjoying playing with them. And using them for stories. Did you guys see my Twitter thread? I don't think I showed you guys this yet. So let me get over to Twitter. And I'm sorry, X, Twitter, whatever. I can only know it as Twitter. It's just the way
I call
I
it
am.
Twitter.
It's Twitter forever.
It's Twitter forever. I'm sorry, but I'm too old to change the name of the app that I've been on forever. And it's always been Twitter. All right, let me show you what I did with the Legos. And I think I've developed an entirely new kind of journalism. Let's call it Lego journalism. But I love this. Look at this. All right, here we go. A story using Lego. In 2014, a prosecutor with the Valhalla, you're killing me with your Lego noise again.
I thought I muted it. I thought I pushed it that time.
He's pawing through it. He's pawing through it like Lynette pawing through the dumpster behind the Winn-Dixie.
Somebody said he sounded like a rat in a Lego dumpster.
This is what I'm working with, Megan. I got all these teeny tiny little pieces in a giant Ziploc bag. That's all I'm working with.
All right, you're forgiven.
I need the freeform bucket. I'm going to get one.
A story using Lego. In 2014, a prosecutor with the 8th District in Florida, Levy County, took a trip to the tanning salon. And here we have the tanning salon. How do I get to the next one? Oh, yeah, here. He checked in at the desk and reserved tanning booth number 3. Shortly after, 51-year-old Judith Rivera came in and reserved booth number 2. Just after undressing, Ms. Rivera looked up and saw a black cell phone pointed at her, recording her from booth number 3. She screamed for help. Now, guys, look at the facial expression that I found on this Lego. Is that perfect or what?
Yeah.
It's so good.
It's so good.
It's so good.
The store employee confronted the prosecutor and told him he knew what he did. Ezel, who was running out, said, "I don't know why you say that," and he left. Police came and took statements and got Ezel's information from the clerk. This might be my favorite one. Prosecutor Ezel was charged with voyeurism. I need some handcuffs. Handcuffs would have made this perfect. Yeah. And what happened to Ezel? Stay tuned because the court hearing is next.
Do we know how old? Sorry, go ahead.
Ezel pled no contest and got probation. Look, he's got his selfie stick in court. Do you see that he has the selfie stick in court? Ezel pled no contest and got probation and lost his law license. But there was a bar hearing where no less than 5 Eighth Circuit judges and prosecutors testified as character witnesses to get his license back. And then I said, it's time to, we shall now move on from the Lego portion of this story because the people who got him his bar license back deserve the public to know who they are. And then I showed them all the things I showed you earlier in the earlier stream about what they all said in court. But I think I've discovered a new kind of a new form of entertainment journalism using Legos to tell the story.
I think you're onto something.
Yeah.
I think I'm
In
onto
this
something
proceeding,
here.
Yeah.
In
I
that
dig it.
this court brought to the attention of the litigants that the statutory change of October 21 and added additional.
Do we know how old that
Oh
young
no,
woman
hold
was?
on. School's
phrase,
calling.
quote,
Hold on.
directly or indirectly, unquote, and the phrase directed at, quote, or pertaining to.
This angry
unquote.
fox.
Those 6 words.
Done it again.
Were commented upon by this
Shut
court.
your big stupid mouth.
They were commented upon in the footnote of Strober versus
Oh, that
Harris,
one's he's
issued January 5,
something.
2022 by the second DCA at
He's always got the
332
best
Southern
school
3rd,
stories.
1079.
I know. Well, apparently,
Also,
we'll listen to the court.
as stated in the most recent second DCA opinion, most specifically, as I mentioned before, but it's worth saying again, in the concurring opinion of the Chief Justice, that the court needed to narrowly tailor so as not to infringe on the rights of the respondent, and specifically with regards to
But
that.
we're gonna do it
at
anyway.
56 minutes and 34 seconds into the proceeding of 12.
No, he was not drawing guns at school again. That's not what happened. He went to the nurse. The nurse had to call me. He's got a neck ache. He did tell me this morning he thought he slept on it funny. So she just had to tell me, look at the fish. Look at the fish. Look what I did. Look at this. Let me make this bigger. This is hysterical. So I was making a garbage can. But I couldn't find the proper lid. So I stuck a pan on top of it and the fish can go right there. Look, they're cooking fish outside the shit shack.
outstanding.
I like that. I like the fish being cooked outside the shit shack. That's funny.
Well, they don't want their shed to smell like fish.
Right. We wouldn't want the shed to smell like fish. No, we want to keep that out by the shit shack because, that makes total sense. Right. Okay. All right. Moving on.
This court said the following. The language that the court would propose would be, and I read, orally pronounced, what was the court's inclination of proposed addendum to the language. Everybody heard that. Everybody was asked to consider that. At 57 minutes and 39 seconds into that proceeding.
Oh, yeah, we heard it all right. We heard it like 8,000
In
times.
response to counsel's comment was kind of a consensus that really that language as proposed was I use the word stretch. I mean, just as a broad definitional pronouncement of the definition of cyber stalking as amended in October 21 by the legislature. But the court also said that it was the court's intention that the court, trying to narrowly tailor it and not to infringe
The
on
court.
his other rights.
The court.
communication, and
God,
or
he loves
speech,
that.
except as it relates to this person or individual.
His choice in
as
verbiage
petitioner
bothers
is
me.
Preston.
It's just so pretentious.
That was the statement of.
Exactly. He's a professor. What do you expect?
Ipso facto, de facto, this, that, Latin, and I hate when he says, and number 2, that should have been number 1. Well, then fucking make it number 1. And don't go back
Yeah.
and tell us that it should have been number 1. Just make it number 1. Like, he just likes to add extra words.
Exactly. He's a
like-
law school professor.
Mhm. God, it's awful. This is, the expert nailed it the other night when he said that this was like a law school class where he gives you a word problem to solve. And he's like, okay, so Uncle Joe slips and falls and who's liable. And let's look at it from every possible angle we could possibly look at it from.
Completely unnecessary.
Oh, it's so unnecessary.
Yeah.
It's so outrageously unnecessary. This man is just wasting everyone's time. I don't think narrow means what he thinks it does. Yes, that's right, chat. That's right. I'm getting backed up on super chats. Let's not do that. Let's read them. Tracy Fagan, thanks for the super chat, says, I was behind and it told me unavailable. Yes, there was a problem. We remedied it. This is a new stream. Welcome back. Jennifer Whitaker, thanks for the super chat. Please edit the previous live to take out the boo-boo. I had to take my dog out and missed like 15 minutes. I restarted in 2 minutes later. Poof. Well, that's good. That means it worked. Yes, I will. I'll edit it and put it back up, but you're going to have to give me several hours on that. David Dowler, thank you for the super chat, says, Megan, if you use VMs, then you will be protected. What's a VM? What's a VM? Anybody?
Virtual machine.
I don't know what that means.
No idea.
It's kind of like, it isolates your system from things.
Oh, well, that's something I can't afford. That sounds expensive. Vicky, thanks for the super chat. Google struggling
It's
mom
not.
adopts sickly baby. The Daily Sun out of Northport. They have article about how she supposedly got the child. I think I saw that, but I will look it up again. Somebody they took it down already, but it's on the Wayback Machine. Cherry Pop Pow, thanks for the super chat, says, we got you, Meg. Chat loves you. You're the best. Aw, you're the best. Thank you. I love you too. Lady Tammy says, new filing is in your email. Awesome. And I will not share that on the screen when I go to pull it up for myself. Psychic Angel, thanks for the $2 super chat, says, use a mask for a tarp signifies all the masks. That's not a bad idea. Ruth Mobley, thanks for the super chat, says, thank you, Megan. Would you also please post the link to What the Hell GoFundMe on the top of your chat? Thank you. I did. And it's pinned right now. So you can go over there and help them with their legal fees if you should want to. Claire Kershaw, thanks to the super chat, says, I have trouble sleeping, so I play these videos on this and the judge's voice knocks me right out. A lot cheaper and safer than pills.
Oh,
That's
I
what
get
people
night
do to
terrors.
my late night streams. That's what people say.
Oh my God. Thank you for the super chat. Canada is watching. Can Lynette go bankrupt when JH wins costs? Is she obligated? Well, the problem is he can sue her for everything, but if she has nothing except Turtle Purgatory, that's all he's going to get.
Right.
So I don't know. I mean, he can take her property if she loses a lawsuit, but I don't think she has any money. He can take her truck. That truck's pretty expensive.
Yeah, and if it's an intentional tort, she potentially cannot discharge it in bankruptcy. So
I would assume
that's what we saw with Amber Heard.
I would assume that Turtle Purgatory is in the 501c3's name, not her own. So I would assume that she's got absolutely nothing.
Yeah. I mean, how much could that possibly? He must know he's not suing for money. He's suing
for sure
to make a point. He's suing to get a judgment. That's all. Tracy Fagan says, OMG, he is still talking. Yeah, he is. Sarah Marie, thanks for the super chat, says, have you guys seen Lynette's partial depot yet? I have, but we haven't played it on this channel yet. We're going to have to do that because it is crazy.
You haven't played it yet?
No, I haven't.
We did it 3 nights in a row. Everybody kept asking for it 3 nights in a row. We played it 3 nights because I had to get Gosney's reaction the other night. Oh, it was priceless.
I loved Gosney's reaction. I was dying.
And Kaiser, we broke Kaiser. Pineapple.
It was pretty funny. We should play it on this channel, but I've been kind of hoping to get the full thing, the full depot, but that probably won't happen until all of this is over.
Yeah, Jeremy has already said he will not release it until after everything's done.
Right. But I would like to do the whole thing. I can play the clips, at some point, but Judge gets paid by the word instead of the hour. Thanks, Amy. I appreciate that. And it does feel like he thinks he gets paid by the word. Rogue Mama, thanks for the super chat, says Lynette literally only has a bucket to piss in. It's sad. Yeah, that's what he can take from her. He can take the shit shack. He can take Jeremy. You're going to get the shit shack in the settlement. That's what you're going to get. What the Hales says, wait until we release the 7-hour depot. Best $2,000 I've ever spent. Jeremy, I can't wait for that. Can you
I can't.
please, if you
Can
are
you send
gonna,
it to us?
if you're gonna live stream it, can I come on and watch it with you? Like, I really want to see it. I want to watch it with you, or send it to me or something. 7
Yes.
hours. You know what
I'd
you
like
should
to
do?
watch it just to have it and just be like, oh, you guys, you're gonna have to watch it.
I hope. I think you should release it like an hour at a time. 1 hour, like a Netflix series.
It's a
We
series.
can make our own documentary of this. Honest to God, let's just Lynette's Depot as a documentary. It's going to be the best comedy we ever saw.
Lynette's Depot, a 7-part special.
But I think a lot of it is her pleading the fifth and avoiding things.
I plead the fifth.
Yes. It's like you're gonna plead to every question I ask. I don't know. You are not a nice person.
JH loves Garbage Pail Kids. Bet he never thought he would have the Garbage Pail adults as neighbors. Garbage Pail adults. That's funny.
The court took a break. The court provided that language for consideration, and at 1 hour, 3 minutes, and 21 seconds, counsel for the respondent stated no objection to the language you proposed. At 1 hour, 5 minutes, and 0 seconds, respondent's counsel
0 seconds.
0
in response
seconds.
to the court
Who
stated
says
he did
that?
not
He's
object.
such
Somebody who's just
ass.
1:06:15
he's an ass.
seconds, the court stated, I'm going to add the language, read again the language that I went and typed on the break and brought it to the court's attention. Again, no objection, no question.
It doesn't matter if there was an objection or not,
no
if it's
modification,
unconstitutional.
Acceptance.
Facts.
And then on top of that, because it was the court's obligation, and I prefaced it with Mr. Hales, I'm not suggesting you're gonna violate the terms of this, but you're entitled to know, and here I
Wait a
am
minute.
telling you.
Hold
a
on.
Violation could result in prosecution, could result in
Hold on.
contempt.
Is he suggesting that there's no problem with violating Jeremy's constitutional rights because his attorney didn't object?
Yeah. Well,
Oh,
that's why
hell.
he's going back now, because he was
Hell
okay
no.
with it until that Budlove decision came out, and now he has to change it. Well, they didn't object. Well, I mean,
Well,
doesn't mean that it's not violating his constitutional rights.
and anyway, his attorney barely objects to anything. He doesn't
Yeah.
object to anything
Yeah.
because he acts like he's scared of this judge or something. I don't know, but he does not object where he should.
They need to be careful with their table talk at their table, because when you're listening to them talk about the protective order and the distance, you can hear Shockett and Jeremy talking about the distance. Like there's something about 534 feet. So if that's outside, their driveways are far enough apart and so he didn't hammer down on, well, hers, she only has a 10-foot requirement along the road in front of their house, and his is 500 feet.
That's crazy.
So, yeah, that was something you can hear it on the tape.
All right. Well, I don't think he objected vociferously enough, but that doesn't mean that the judge is correct and that he can do it just because it wasn't objected to, because it can always be appealed, right?
Yeah, I mean, that kind of stuff happens all the time where something's missed, but that's a constitutional violation. But
You only waive your objections, as far as I know. You only waive your objections during like depositions, right? If you don't object.
well, in jury trial, but this was something that apparently under the current case law that there was no decision on it.
Right. So
And
it was
there
unclear.
no case law, it was unclear. So I mean, he could have objected, but because there was nothing saying that it for sure was wrong, I still would have said it's a improper prior restraint on free speech. But
I'm shocked I'm shocked that his counsel did not argue that. I am shocked he never said this is a prior restraint on speech. Maybe he just knew, but to get it on the record, at least he knew the judge was going to go against them. But just to say, for the record, Your Honor, this is a prior restraint on speech. It's unconstitutional. And for the record, I want it in the record. Mimic the judge. And for the record, the record, Judge, I want it on the record that I told you today that this is an unconstitutional order.
Yeah.
For the record, because that's for the appeal. It's like, what are they doing that they're not? And I'm not trying to criticize his attorneys. I have no clue what kind of pressure they're under from this judge,
Exactly.
or I have no idea what it's like for them in this tiny place with all this corruption. Like, perhaps they can't do that. I don't know. But Jeremy needs, you know what he needs? He needs an attorney to come in from out of the county. He needs an attorney to come in from a real county who doesn't give a shit about the Eighth Circuit. He needs an attorney. He needs Greg Anderson. Oh my God.
Greg Anderson or Steve Gosney.
What about, oh my God, can Gosney step in?
That'd be amazing.
For the right price, he probably would.
Oh, Jeremy, you have $100,000. For $100,000, Steve Gosney will come in and burn it down. He will burn it to
He
the
offered
ground.
it on, what was it? Who was it down in Florida that had the mistrial? Was it?
Oh yeah, I remember. He offered
Melly or whatever. He's like,
he-
Something like that.
for $500,000. He said he would come in and do it. He could though. He could come in and burn this shit down. He needs an attorney who will come in from outside. And it's not there. I'm not blaming Randy Shockett. I'm not blaming Doreen. I think they're both good attorneys. They certainly write good motions. But I think that they need somebody outside of the circuit who doesn't practice here, because the backlash must be a problem. That's how it feels.
Because I'm sure they practice in front of those judges all the time.
Right.
Yeah.
Right. Hey guys, get that GoFundMe going, because maybe we can get Larry Foreman to fly in.
Yeah.
Larry will do it.
Larry's he seems a little frustrated with the situation. He seems hot.
I would love, oh my God, wouldn't you love to see Larry Foreman in front of this judge?
That would be great.
Oh, he would.
He'll get thrown in jail.
Oh, he would love that. Bring it. God, I would love to see it. I would love to see it.
More money off of that than you can imagine.
He would make so much money off of that, guys.
And we would too.
We would too. Get to the GoFundMe and start sending some money, because if he can hire Larry to come in and carpet bag in there and give this judge what it's like to face a fiery lawyer who doesn't give a shit what happens after that. Hire Larry. I know he is. No, he's not licensed there, but he can. There's reciprocation.
He can pro hoc vice in there for that matter only, and get it.
Yep, he can pro hoc vice.
As long as Shockett sponsor, as long as a licensed Florida attorney sponsors him,
right?
For that, so Shockett can say, "Yeah, I'm going to bring him in as co-counsel."
That's right. See, Johnny Depp's lawyers were from California, but they went to court in Virginia now, didn't they?
And they had they had to have a local Virginia attorney sponsor them for that. Even if they didn't do anything.
But you can do that from state to state, right? It's pretty much all states, right?
Yeah. You can do that. I could do that for another state. I wouldn't, but I don't have time to do that. But you could do that. I mean, you can do that in any state. You can do that in federal courts as well. But yes, it happens all the time in state court.
Yep, that's what should happen here. He needs somebody to come on in from someplace else and just bring the fire down in this courtroom.
Aussie Just Jen said he needs to wear a big ass buckle.
Oh my God.
Spurs on his boots.
Yeah, buckle up, Judge.
And then we walked away.
Oh, that's funny.
And so to the extent, and I want to hear from you, counsel, to the extent that you feel that this opinion should change or modify, it's a request to modify the language, to the extent that you feel this opinion should modify what the court's belief on 12.6 was already the intent, maybe I didn't carry it through, that may be your objection or your argument, to narrowly tailor it by not directing Mr. Hales to take down anything prior to that date, but to prospectively follow the language in the addendum. And so what is it about that language that you think, in light of Budlove, is not narrowly tailored? And again,
I chuckle every time I hear that name.
what Budlove does is reverse
Budlove.
the second DC. It upholds
12
five
12 years
injunctions
old.
for protection against stalking. It upholds the findings, but it reverses on the language of the injunctive relief being too broad.
Right.
It doesn't tell the court, it says what's too broad, but it doesn't say what.
See, I
would
pushed the
narrowly
button that time
tailor.
and it didn't mute. I apologize.
It's giving the trial court the obligation to invest the judicial labor to narrowly tailor it.
Well, Your Honor, on page 7, I think it does. At the bottom, injunctions which, quote, prevent communications to, unquote, an individual can be permissible under the First Amendment. Communication to her, but this is social media. No one's she has to watch the video. She has to subscribe to his YouTube account to watch it.
Yeah, but hang on, read
Okay,
the
then it
message.
says-
She doesn't have to
I
subscribe to it,
do
but
not
she has to
have
access it.
Subscribe to
It
watch
cites
his
to the
videos.
David decision, which the second DCA says we're in conflict with, and we wanted to certify it to the Supremes.
But yes, but Judge, there's no first DCA opinion in conflict here, so therefore, this is effective. This language, I'm saying this is a clarification. This is an important opinion. I can go back and read the briefs. I'm sure there was arguments on both sides saying that injunction in this case, the Budlove case, which really matches yours, was constitutional and consistent with the statute. I'm sure there's arguments on both sides, Judge, until we had this clarification. That's what appellate opinions do, Your Honor.
So, give me a so, again, the court's oral pronouncement on 12-6, which was reduced to writing, which was not objected to, is there not a distinction that there's waiver?
Oh, I don't think any litigants or even trial courts can waive the Constitution of the United States. The David opinion, Judge, was when the old
Nope.
statute.
Nice.
That was under the
Well
old
put.
cyberstalking
Right.
They
statute.
cannot.
So what they're
The
doing
opinion
is,
the Chief
so,
Justice says really is inapplicable because it was interpreting a statute that didn't include 6 words that included directly or indirectly, or directed at or pertaining to.
right, which is why this is why this judge, I think her name was Justine in Pasco County, her ruling was consistent with yours, her injunction had the same language. There was no objection there either because this is a new statute. You pointed it out. This is new law.
And so, let me pull up the language that's in, I guess my question is, what are you suggesting should be the limitation or the modification? The motion is to modify
Right.
the language. And so, just for the record, so that's clear, the protection involved in, or implicated in the extended temporary injunction for protection against stalking issued 12-6 is the standard language of the Florida Supreme Court form 12.980 subsection U, with the addition of what's called addendum, which is attached to and made a part thereof, and under subsection 5 of the order adjudged, it says, please see attached addendum, and the court added the additional language. So what is it about those 2 paragraphs that the court wrote and included as part of the injunctive relief needs to be modified? I guess I'm inviting
Sure.
suggestion.
It's almost a gag order. You can't go on Facebook or anywhere and mention her name. You can't mention her name, show her image. You can't do anything. That's overbroad. That's
Crazy.
not narrowly tailored. That's what it says. You can certainly, the other language, the fighting words, incitement, these words, these are unprotected, and so and also any kind of communication to her is everything else in there is standard. This new area of gagging someone, basically saying, if you go on YouTube, Facebook, TikTok, whatever they got out there, and say her name or anything about her, you're enjoined. That is a prior restraint on constitutionally
There he
protected
goes.
speech.
There he goes.
Finally.
Given the conflict.
There you go. There you go, Randy. There it is. There it is. Damn.
Statute that the
Only
legislature
took how long?
changed this
All right, we can't be too rough on him.
indirectly. That
This poor guy. To be fair, when has he gotten a word in edgewise? Really?
Yeah, true.
language, wow, it opens up a Pandora's box. So I
want
think
to
it's
hear that
appropriate
again.
to mention her name. That's you can't mention her name, show her image. You can't do anything. That's overbroad. That's not narrowly tailored. That's what it says. You can certainly, the other languages, fighting words, incitement, these words, these are unprotected, and so and also any kind of communication to her is everything else in there is standard. This new area of gagging someone, basically saying, if you go on YouTube, Facebook, TikTok, whatever they got out there, and say her name or anything about her, you're enjoined. That is a prior restraint on constitutionally protected
Damn
speech.
straight it is.
And given the conflict with the new statute that the legislature changed, this indirectly, that language, wow, it opens up a Pandora's box.
Yeah, the
And-
statute itself is unconstitutional. But
Yes. Thank you. Oh, wait, who's
Because-
going over that? Isn't somebody going over? Was it you that was going to go over
I went over
the?
I went over the Strober v. Harris case that Judge cited to so many times in the first few hearings.
Yeah.
But I haven't gone through the Bud Love one yet.
Oh, well, I want to go through that actually. I'm going to read that. I read it
Yeah.
I read it when I saw it referenced, and oh my God, it's a great decision as far as overturning all this bullshit. But I haven't read the entire thing in very detailed. But dang.
Yeah.
This is exactly correct. And I feel like the only thing he's missing here is after telling him that it's a violation of the Constitution of the United States that
You will pay for what you've done. And I pray that God send angels to visit vengeance upon you.
that's the only thing it was missing.
I love it.
That's the
Yeah.
only thing that little speech there was missing. Randy, I recommend putting that in the next time after you tell
Yes.
him you violated the Constitution, and I pray that God send angels to visit vengeance upon me.
I gotta go. I just got back to the office after driving for 7 hours today.
Oh my
So
gosh.
I gotta go in and do a little bit of work before I head home early. So,
All right. Well, you tell
Thanks for
everybody
having me.
what's your next stream? What are you doing?
Tonight I'm going to read the new federal petition.
Oh yeah, that's
by
right.
Jeremy.
That's right.
I have a copy of it. I'm going to read through it tonight on stream. And then whatever time we have for stuff after, maybe a short stream tonight too, just because I need sleep. But I do want to
I
read through
know.
it. I don't have any of the other hearings. You have the uncensored hearings, so those are cool.
Yeah.
But yeah, I'm
well,
going to read through that tonight.
What did I send you? I'll send you this one too.
You sent me the first hearing, I think, uncut.
Okay, I'll send you the second one and this one too.
I went through the second one based off of their channel. I'd used those videos. We've done the first two hearings.
All right. Well, I'll send you this one
yeah.
then.
Okay, cool.
All right.
And,
See ya.
Yeah, thanks for having me on. You guys got me over 5,000 subs. That was like, that was awesome.
Go subscribe to MG Law. I
was-
dropped Valhalla's chat or his link in there as well. Subscribe to both of these dudes. They're good dudes.
Thank
Yeah,
you.
it's because you got me on. You recommended me for this last week, and it's been a crazy ride. So yeah, I have you to thank for it. So
Well,
Thank you.
great. I'm glad to
Congratulations,
see it.
MG.
so thanks.
Congrats.
See y'all later.
All right. See
Later,
ya.
buddy.
Bye. Bye.
All right. Here we go.
Before
I-
before we start, real
Yeah.
quick, I think I've made something work.
Ooh, let me see. Let me see.
Here's what I'm going to move the camera, so if you get motion sickness, bear with me for a second.
Okay.
All right. So we've got random junk, lots of sharp little pointy things all over the ground. We've got
Oh, this is
the
perfect.
barn, little poop in the barn because there's always poop.
Right? There's animals wandering around.
There's the garden
What is
hose,
that?
the garden
What is-
hose to fill up turtle tanks because we need
Oh
that.
my God. But wait, do they have hose? They have water? What do they have? Like a rain barrel hooked
I
up
think
to the
it's-
hose?
I think it's running to the Hales property across the street. Don't worry about it.
Don't worry about it.
And then we've got one single bed in the very top because, why not?
Why not? This
Why
is
not?
awesome. Look at this, how it opens up and everything and how it has no walls. It looks exactly right.
It's perfect.
It's perfect. You are very talented at this. Oh, do you have a barefoot child that could run around near
Ooh.
the bones?
I might be able to pull that off. Hold on.
I've got, so this is what I'm working on here. Let's see. So I've got, all right, the shit shack is shaping up. We have random junk in the front. We have sharp, pointy things coming out of one side. There's random tools with an axe attached. This is like a gauntlet for the toddler to get through. So there's like an axe you have to avoid. There's broken glass on the ground, a random chicken egg that
Nice.
a chicken just dropped. There's pointy shards of like shrapnel here. This is like some kind of random like windmill or fan or something that's broken. It doesn't work. It's just a pole that could fall over at any moment.
It's going to work next year.
The fish just fell onto the floor. Hold on, wait. I got to get the fish. It fell. So we have a garbage can with that we can burn the garbage, and while we burn the garbage, we can cook on it. So there's this frying pan there, and then we have tarps that are sort of covering the composting toilet, which is the blue bucket, which you can see in the, can you see the blue bucket? Yeah, there's the blue bucket. And then we're gonna at some point we'll get like some sort of cover going over this way, and then probably some more tarp. So we're working on it.
It's getting there. It's
Getting there. I like the toddler gauntlet. That might actually be the toddler gauntlet might be like an entire ropes course that I have to build coming off of here. So it'll just be like all these different hazards that the toddler has to get through. So we've got the swinging axe and the random tools, power tools. Like this is like a power tool. And then like chicken, rotten eggs, broken glass, shrapnel. And then, at what point will my child want his toys back? He has so many Legos, he will not know they're missing. He will not know. And don't worry, my husband will just buy more because clearly he has a problem. Because if you saw how many Legos I have, you'd be like, what is going on?
I wish I had all my Legos from when I was a kid.
Oh, we have some of my husband's. So his mother saved a bunch of his Legos and he got them the last time we were visiting them and put together like an entire set. It was like a pirate ship or something from like 1985.
Nice.
It's really cool.
Very
so
cool.
Yeah, I think Turtle Purgatory is coming along nicely. The next thing I might take a break from the shit shack because I still have to make a sign. I have to make a sign that says shit shack. But I may start working on a turtle pond with this green water as a base.
Perfect.
And I'm gonna need to make turtles. So I had brought out these little round things that I was thinking of trying to make turtles with. But I'm not sure how that's going to work. I may have to sit and think about that for a minute. I think that I could do like a head, like stick a head on, and then find a shell that can like kind of, I don't know. I'll find something. I'll find something.
Creative.
I'll get creative. We'll figure it out. We've got more bloviating from the judge, but the argument from Randy Shockett was just getting really good. So we'll listen to him some more.
I think the other opinion is wrong too by saying you can't do that. No, you can narrowly tailor it. You can't tell him what you can't. He can say what he wants. No, you can't. There's certain he can't threaten her. There's certain fighting words he can't do. That's still enjoined. What this blanket is overbroad, Judge. If he basically went on YouTube and said, by the way, there's an issue of what her legal name is, but Michelle, whatever, said her name, he's now subject to criminal violations of free speech, which is constitutionally protected. I think the opinion is very important.
So, two things. One is, Bud Love, as you know, is a case where
Oh, here we go with Bud Love again.
Every time.
parties and or litigants and or people brought into a piece of litigation in a looks like a Chapter 39 termination proceeding.
Something like that, yeah.
Those participants were being commented about in social media. And ultimately, the
So
court
what?
said as to those 5 persons that they were being stalked, and this DCA upheld the stalking
Correct.
injunctions. So
They had
it's
to
a
have
little
been
bit
wrong
different
about
in
that. How can talking about someone online be considered stalking if you're talking about them and not talking to them? How can that be considered stalking? We're going to have to read this decision because it sounds insane to me.
Everything about this case is insane.
I found poop. Oh my God,
Nice.
I found poop. The poop is going on in the shit shack. Should it go on the bucket? Like, should I
No,
put
it's
it-
not going to be on the bucket. It's going to be somewhere on the ground or,
Okay,
you
we'll
know.
put it next to the bucket.
There you go.
Like somebody missed the shit shack
There you
shitting
go.
bucket. Or you know what? They just didn't make it to the shit shack. So it'll be like over here. We'll put it in the gauntlet section. The toddler gauntlet. We have the toddler gauntlet there. There we go.
Lynette School of Parenting.
Yes.
Toddler Gauntlet.
The toddler gauntlet. Shit, what did I just... Oh, that fish just doesn't want to stay in the pan. It just keeps jumping out. It's just a whole problem. All right, here we go.
the basis of this petitioner's complaint is that the postings themselves, so those were postings about a court case. Bud Love is postings about a court case that led to be considered stalking.
Postings
This
about a
case is
court
about the
case?
postings themselves.
How is that stalking? Posting public information is
About a
considered
court
stalking?
case? All right, if that's we're all in trouble then. We're
Oh,
all
yeah.
in trouble because so are you telling me that my livelihood, I report on court cases for a living. That's what I do. I'm a court reporter. Are you telling me that I can be hauled into court for stalking because I'm analyzing a public court case? Are you kidding? All right. Apparently, Bud Love is a case we really need to find out about because this sounds horrific.
I'm excited to learn. But apparently in Levy County, Florida, that would put you in a legal predicament, apparently.
Wow. I'm shocked by this.
Being a large part of inciting and fomenting others to act, and that's the pertaining to.
Let
It's
me
posting
just say,
about-
I have never incited anyone to do anything other than call their elected officials. We've had a couple of calling campaigns here to call elected officials, which is their job to take phone calls from constituents. But I have never incited anyone to act to do anything illegal. Never. What in the world? You're now not allowed to have to use your platform to organize a grassroots campaign to affect change in your community? Are you kidding? This is the American way. This is America. This is what we are. This is what our whole system is about. It's about the people having a voice. And how can we have a voice if we are not allowed to to use our voice to gather people together to redress our government for grievances? Damn straight. What the hell? What?
This dude is this is closer to like a Soviet era silencing through the court, right? This is closer to a socialist hell than it is what I went to Iraq for.
This is terrible. Like, terrible. This is an outrage, is what this is. This is terrible. Ugh.
her in a manner, this is how it's alleged.
His entire position on the bench should be to prevent violating
That's
Jeremy's
Of
rights.
course.
Not
Of course.
not to allow it and say, oh well, it's okay. That's the entire purpose that man's there, is to preserve everybody's rights.
mostly causing, it's not limited to, but it's mostly causing other people to act upon of persistently, consistently following, videotaping, writing about, which included
Writing
threats
about?
construed as possible.
Okay, videotaping is one thing. Like, don't videotape her. Like, don't go do that. Don't contact her. Don't email her. Don't contact her at all. Don't contact any of these people. The only people that should be contacted are like, I don't know, legislators, possibly the Judicial Commission. Like those people are supposed to take complaints. But don't go, but to write about her? Now he wants to put journalists out of business? She has become a news story, whether she likes it or not, and whether this judge likes it or not. Ask MAGA Granny how she feels about being written about. Ask that woman that the mainstream press doxed on live television who shared a Russian meme during the 2020 election on Facebook. Ask her what if she could go sue the media for cyber stalking. Ask the kid who CNN doxed for posting a WWE meme with Donald Trump's face on it. Ask him about cyber stalking. They have no recourse against CNN. This is garbage. This is all garbage. If you think you've been defamed, your only option is a defamation lawsuit. A judge cannot step in and say, you must stop saying all those bad things, because the judge can't make the determination if it's defamatory or not. The judge is not there to make that determination in this kind of case. You would have to go to a judge in a defamation civil case for that. This is the improper venue for all of this shit that he's trying to do. Improper venue. Wrong. He's a fucking family court judge. He's an absolute disgrace. He is a hack. He is there to just look at the order and say, does it have merit? Is there evidence or not? And say yes or no. He is not here to determine what your constitutional rights are. He is not a Supreme Court justice. He is not even a real judge. He's not even a criminal judge. This guy is a fake fucking judge. He's a kangaroo judge in a family court that uses hearsay as evidence. If you think that's a real judge, I have news for you. It isn't. He
Megan,
isn't.
How dare you, ma'am? He is a family court judge, and that is obviously the best place in the entire world to rewrite First Amendment restrictions. Obviously, this is the appropriate format, time, and place, and I will hear none to the other. It's ridiculous.
Family court judges, to quote Judge Judy, family court judges are morons and political hacks. Take it up with Judge Judy if you don't like it, Judge Grudge. But that's what you are at this point. And you have no business at all determining what my speech can be. You are so far beneath where you need to be the person deciding that. Like, it's not even funny. You don't matter, Judge DeThomasis. You are literally there to like ruin people's lives in custody disputes. That's your job, to ruin people's lives and rip children away from their one parent or the other, because for some reason we've given you that authority to do that. So why don't you go do that and figure out what is the deal with the custody of Lynette's kid? Because that would be your purview. You know what your purview would be? You know where your wheelhouse might be? Why don't you determine whether or not that adoption was actually legal and whether that woman has a right to that child? Because this is family court, right? It's not the Supreme Court. It's not the Supreme Court, Judge. You're not a Supreme Court justice. You're literally overstepping your bounds. You are overstepping so far that you're going to fall into turtle purgatory soon, or perhaps maybe the tanning salon that's attached to the courthouse, my courthouse over here. Oh, Jesus. I can't take this guy. I cannot take him.
He's a trip. He's an
Harm,
absolute
possible
trip.
violence, financial consequence of disastrous consequence to her and her non-for-profit, labeling her child abuser, a criminal, etc. So it's like it started that the nature of the communication that was being published was the basis of the injunctive relief.
Well, it shouldn't have been, because the nature of the communication wasn't your job. Again, those things are only illegal if they are untrue.
Truth is an absolute defense to defamation.
And he has not heard one bit of evidence to prove to him whether those statements that were made by Jeremy Hale were true or false. Now, one of the things he just brought up is that Jeremy allegedly called her a child abuser. We have all seen evidence that there could be child abuse going on in this situation. So if his opinion is that she's a child abuser, there's a whole lot of evidence that says he might be right. And if he is not intentionally being malicious, that's also not defamation. So let's say he's wrong. Let's say she's not a child abuser and he thinks she is and said that he thinks that she is. Defamation is, you also have to prove malicious intent. And I don't think he has malicious intent about that at all. I think he has a real concern about this kid. I have a real concern about this kid. I have a real concern.
You also have to prove damages, which I can't think of a single thing that this lady's getting damaged.
People are talking about her, Valhalla.
That's not a damage. That's not
but
damage.
That's what the judge is saying. The judge here is saying that just by talking about her, she is being damaged. Well, but is she causing the damage herself? Is she causing the people to talk about her is the question. Yes.
Yes.
This is like Laura Owens trying to say that she has a right to privacy after she went to the press and put herself out there in all of her shit and her fake pregnancies and stuff. And now she wants everyone to shut up because it's damaging to her. No, your own actions have damaged you, not the press.
Her own child, stepchild, foster child, whatever the YouTube girl is. She herself has validated abuse claims. So I don't understand how this could possibly be a defamation case. It doesn't make any sense.
She has not only just said it on YouTube, there are documents that back that up. There is court documents from her child psychologist or psychiatrist, I don't remember which one, who had direct contact with Lynette and this child, said there was extreme abuse and that she should be removed. So, and I have those documents. They're in my possession. I may read them on a stream one day, but we'll have to redact a lot of information off of it. But that's, it's in court. It's in black and white. So if you read this document and you see this psychiatrist, this professional, the court hired to determine whether or not Lynette was abusing someone, and then they find that she did, and you say she's a child abuser, that's what the record says. So Jeremy's not the only one saying this.
No, not even close. MG corrected me. He says, if the judge were to find defamation per se, then damages may not need to be proven, but there's enough evidence there to dispel that kind of claim. So thank you for that, MG.
Mm-hmm. Yeah. The judge is just taking it on her word that all of these things he said were untrue. And he has not asked, what is your evidence for saying these things? And he shouldn't anyway, because this is not a defamation case. And that is not the issue in this court. The issue is Jeremy cyberstalking her? Saying things about someone online is not cyberstalking. You would have to be saying them to them directly through their email or other communication towards that person.
Not that it's that the postings grew out of another piece of
Be
litigation.
back in just a couple minutes.
What we don't know is
Okay.
what's the trial court going to do when Budlove et al. Gets sent back to the trial court. And so, number one, in that context, I'm asking you, and the second part of it, or 1A of my question to you is, what are you suggesting would be, given that I read, my intent was to narrowly tailor. My intent was to not infringe on constitutional rights. I did that in the previous temporary injunction. I did that, in my opinion, in the addendum that was not objected to.
Wrong.
And so to the extent that this opinion may change your client's view and your view about this, I'm asking what would be, or, you're telling me the whole thing is overly broad?
No.
Correct.
There it is.
It's just,
And-
he should
and
be allowed to post, he should be allowed to.
The injunction
freedom of
is going to
speech.
tell him what he can't do.
I
I'm
understand.
not going
but
to tell him
right
what he
now-
can do.
well-
That's for you, as his lawyer, to advise him that based on the court's ruling, you could still do this, but the court's ruling says you cannot do that. If I'm going to enjoin, which I have, the court's order is going to read what he can't do. And so right now it reads, based on the totality of the circumstances presented to this court in prior pleadings and in the form of evidence presented to this court on 11/29, and based on the extension of the injunctive relief, etc. So it goes on. It is therefore ordered and adjudged that in addition to the conditions and restrictions previously imposed, which is the standard, so that first paragraph really doesn't do anything to enjoin. It just simply says why we're doing this, why the court's doing it. And so it's the second paragraph. The respondent and or anyone under his control employed by him or in any way under his direction, including but not limited to any and all administrators of any form of social media, has the
administrators.
responsibility to assure that he does not publish in any form whatsoever.
Well, how can other people be responsible that he does not publish anything that you, this stupid judge, wants him to not publish? Other people, you're putting other people in other states. You think you have jurisdiction over his moderators in his chat to make sure that they don't allow him to post anything about her? What kind of absolute garbage is this? Is so insane. He has got to know how insane he is. This is a guy who allegedly studied the Constitution of the United States, allegedly, and earned a law degree. Whoever gave him that law degree should take it back immediately. I think it was the University of Florida, and I think that they should get it. I think that's where it said he was affiliated, and I think they should go and get it back, like as soon as humanly possible. Because what the hell, man? You think you can hold other people in other states that you don't even have jurisdiction over responsible for his speech? Wow.
Utilizing any media platform or conduit of information of the name, image, and or likeness, and or any information, data, photography, videos related to and or pertaining. The
name, image, and or likeness. So you can't go into AI chat and into AI images and put up a likeness of her. It's not even her. Can I draw her, Judge? Am I allowed to draw? Can I make her a Lego figure out of her? Can I put her, because that's a likeness. Can I make a pencil stick drawing and say it's Lynette Preston? No, he doesn't want us to do that. We're not allowed to make any likenesses or show her picture. She literally puts her picture up all over social media. She has these videos. She has videos. Like, I just got one in my inbox today. A video of her saying that what's his name? John Cook? She's saying that he's abusive to her. If I play that, is this judge going to try and send the New York sheriff to my house? Because it's her? It's a video she posted in social media? It's unbelievable.
To the petitioner and or her minor child. So it's that paragraph, if you're suggesting.
Well, he needs to go after Fish and Wildlife then, because they posted a video of her and her minor child. Better go after Fish and Wildlife in Florida, sir. They violated your order.
Is overbroad what would be narrowly tailored.
I'll tell you what would be narrowly tailored. Here's what's narrowly tailored. There's no protective order because there's no evidence here that she needs one. What you are complaining about is called free speech. If you think that speech is defamatory, you need to hire yourself a lawyer, ma'am, and go take him to civil court and file for defamation. Period. The end. Court's adjourned. Dismissed.
Okay, thanks, Judge. At page 9 of the opinion, it's right there. We can substitute Budlow for the word Hales. But at the bottom, in this case, the injunctions granted against Budlow, Hales, do not merely prohibit Budlow, Hales from having any contact with the petitioner, sending communications to the petitioner, or causing others to send communications to the petitioner or inflict some manner of harm against the petitioner. Those are fine. In addition to preventing any contact with or communications to the petitioner, the trial court ordered that Budlow, Hales cease communicating publicly about the petitioner, ordering that he refrain from, quote, posting online anything related to her case.
Wait, anything related to her case?
But that involves the individuals, Judge. That's what they were doing. It's not just the case. The individuals, in fact, if you keep reading the order,
Well, the word anything, I guess, anything related
Yeah.
to the case.
In other words, the injunctions, they said it. In other words, the injunctions, on page 9 to 10, in other words, the injunctions prevent Vodovoz Hale from engaging in public speech about a court proceeding and the individuals involved. This
And that was wrong.
content-based prior restraint on speech is not tailored at all, much less narrowly tailored.
There you
The
go.
prospective prescriptions on Vodovoz
There it is.
Hale's social media communications are, for example, not confined to constitutionally unprotected speech, such as fighting words, quote, those personally abusive.
See, that would have been narrowly tailored to say, in that case, to say you're not allowed to post illegal speech about this person. So you're not allowed to incite anyone to violence. You're not allowed to use fighting words, while this matter is in court or whatever. But I still think it's kind of baloney. I mean, unless it's actual threats, like you can't post threats. That sort of thing. Yeah. Okay. That would be the narrowly tailored. You cannot say you are no longer allowed to speak about this person ever again. That's ridiculous. Or show her image or her likeness. No.
Epithets, which, when addressed to the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. True threats, those statements the speaker means to communicate a serious expression of intent to commit an act of unlawful violence, and those are alleged, Judge, I follow you, to a particular individual or group of individuals, or incitement communications, all of these things. To the extent the injunctions broadly prohibit him from merely making public statements about the petitioner or her case, the injunctions are overbroad and impermissibly enjoin a constitutionally protected course of conduct. It cites the statute and crap acts. So I would just say we could just mirror this language. He's enjoined from this. However, he's not enjoined from constitutionally protected speech.
She's
Something
more
like that
protected than Muhammad.
would be fine.
Yeah.
So I'm reading,
Yeah, you can't. This is hilarious. This is Sharia law. You're
It's
not allowed
insane.
to draw her. You can't even draw her.
Right.
You're not even allowed to draw. Great observation, Valhalla. It's Sharia. Don't even think about drawing her.
Don't draw her. Don't say her name out loud. We can't post images. Nothing.
No images. It is like, the immaculate, Mary. You just know you can't do anything to this woman. This woman is off limits completely. Like she's the mother of Christ.
Well, and even worse, she's off
God.
limits to us, and Jeremy may have to pay the legal repercussions for us talking about her, which is
It's insane.
it's absolutely asinine.
You know what else she is actually I think she is a public person. She ran for office. She put her story in the newspaper. She put her turtle rescue in the newspaper. She put her adoption story in the newspaper. She is a public person. So she is there's a higher standard too for defamation when you're talking about a public individual. She's I guess what you would call what is it? It's not
Public
partial.
figure.
But not it's like there's another term. She's not a public figure like a president or something. She's a limited purpose public figure.
There you go.
That's what it is. Limited purpose public figure. She does not have the right to this privacy she thinks she has a right to.
No.
You don't get to go to the media and put your name and picture and your turtle business in the media and then claim no one can talk about you and then go get orders from judges who don't understand things and who think that they're being really, cutting edge by limiting the entire world's free speech through this stupid protective order case in family court. You can't do that. This is all awful. It's all wrong. It's all wrong.
in the second paragraph of this
Jeremy
court's
says she's
agenda,
created hundreds of
regarding
GoFundMes.
belief.
Oh, well, there you go. So again, she's putting it out there. She has a Facebook page about it. She's posting videos about her life. She's posting all of that. Look, I've got some of them. I haven't played them yet, but I have them. If you have posted videos about your life on social media, you do not then get to cry and complain that your privacy is being invaded.
Yep.
And even if, like Laura Owens, if you posted it and it was public for even 2 seconds and someone grabs it before you take it down, like the idiot thing I did earlier, I can't complain about it. I can't sue anybody because I did it. I put it out there. And she did it. She put it out there.
All right, so the respondent and or anyone
I know how to put a smile on your face, Megan.
from utilizing.
Oh yeah,
the media platform-
what'd you do?
Portillo's.
Oh, let me see.
Portillo's
Oh.
beef and sausage combo. It's the
How do
last
you-
of it.
How do you? Did you order that online?
No, Mrs. Valhalla went back up north last weekend to visit family, so she brought me home 2 sandwiches.
Oh man,
That's how I know she loves me.
I think I have some in the freezer.
Oh, it's so good.
Oh man, it is so good. I love Portillo's.
related to and or pertaining to the petitioner and or the minor child.
We needed that.
So one way to remedy that, if you're suggesting, I'm not necessarily agreeing or disagreeing, would be and or pertaining to the her minor child, which is also named in the injunctive relief here being sought.
Yep.
That it could go further to say pertaining and or pertaining to the petitioner and or her minor child that may be construed as fighting words, personally abusive epithets, which when addressed by the ordinary citizen are as a matter of common knowledge inherently likely to provoke violent reaction, and or true threats as are those statements where the speaker means to communicate, etc. And that paragraph out of Bud Love could define, I can tell you this, your
Every
client's
time.
still at risk.
Every
because
time.
that whatever future behavior he engages in or language he behaves in accordance with would then need to be construed as, does it meet that constitutional definition or not?
Yeah,
But that's
true
for
threats, you
somebody else to decide.
moron.
But what you're saying is, I guess I'm hearing what you say, is that the language is currently in the addendum could remain so long as we add, because right now it's a broad, you can't do anything, info, data, photography, videos related or pertaining to the petitioner and or her minor child. And I'm suggesting that if we add, that may be construed as fighting words, which are those personally abusive, et cetera, et cetera.
Constitutionally unprotected, right.
Yeah, constitutionally unprotected speech. And that's a very
That may
narrow
be construed
definition.
as constitutionally unprotected speech, such as.
And you can cite, I think I don't think anything wrong with the order citing Bud Love, but,
Well, I could,
Yeah.
and I would, because I think I'm required to, because that is the status of the law, despite, and I keep going back to the concurring opinion, but I understand 2 versus 1 to win,
Yeah.
even within their, that, as pointed out by the concurring opinion, I would say that, and I'm gonna look at,
That I'm a big dummy and I screwed up. That's what he should say.
Oh, you would
It's not
never
dis-
say
it's
such
not
a
a
thing.
dissent, it's a concurrence.
Right.
However, it includes, quote, however, I disagree with the majority's assertion that in determining what is or what is not constitutionally protected activity.
he's gonna
the court
agree
should
with the
focus on
dissenting
whether the
loser.
communication is directed at the individual seeking the injunction or whether it merely pertains to the individual. It's a criticism of that finding or that portion of the finding, and then goes on to say, because it's based on the David decision at 189 Southern 3rd 871.
This guy is a
which is the old
dumbass.
statute, which is the old.
Which, right,
Okay, I read that part of Bud Love, and the decision that stands is the one he read before that, not the dissenting opinion, but he's going to take the side of the dissenting opinion. He's unbelievable. He's taking the side of the judges that lost in that case.
That's not how you're
Unbelievable.
supposed to do the judge thing, y'all.
No, when the decision comes down and you lost, you don't go then as a judge and be like, but the dissenting opinion was this. It agreed
No.
with me. Well, too bad. They lost. My
The
God.
prevailing decision is what is at that point factual, and there is no other choice until
is
a
no other
higher
choice.
court
Yeah.
appeals
Yeah.
it.
Yeah, he can't
Excuse
even.
me.
He
Which
can't.
interpreted the old statute and then concludes with, in effect,
Well put, MG. It is binding precedent. He doesn't get to side with
I
the
would
dissent.
certify conflict with the fourth DCA's David line of cases that suggest the bright line rule on a prohibition of prior restraint.
Well, that's the great, I
So-
think, yeah.
But nonetheless, the concurrence concludes, and I quote, "I conclude the trial court could enjoin Bud Love from making future statements about the petitioners that incite others to violence against the petitioners, regardless of whether those
Duh.
are directed at the petitioners, without also violating First Amendment rights."
Well, what? Wait.
However,
Even if
the
they're
injunction
not
right now could be
directed at
construed
them?
as preventing Bud Love's posting anything at all. There's two ways to go about it then. One would be to cite to the language previously mentioned, which is in the opinion of Bud Love, or the other is to simply say what it currently reads and then just add limited to future statements about petitioners that do or may incite others to violence against the petitioners, regardless of whether they're directed at the petitioner.
So he's going to add
I don't
language
know-
from the
I don't know
dissent?
which one creates potential.
He's going to add language from the dissenting opinion is what I'm understanding here. Is that what I heard? MG, are you still listening? Is he saying he's going to insert language from the loser side? Because I think that's what I just heard, and I'm shocked by that.
Potentially more problems, but I think I'm inclined to go with the more specific and just take the language right out of it.
Okay, MG law says you don't have to directly communicate under Florida law. You just have to cause it to be communicated. Well, that needs to be overturned immediately, because how do you prove that you caused it to be communicated? How is that proven? How is that? I want to know. How do you? What if I'm doing a stream today, and I talked about a lot of things today about corruption and cover-ups and judges standing up for perverts, and I never once said that anybody should do anything other than contact the legislature if they want to, because that's a legitimate thing to do. I said don't contact anybody. But if someone listening to this stream goes and sends my stream to someone, contacts them, even though I said not to, did I cause them to communicate to them because I told them about the story?
Well, only if there's an accusation, I think, is what the deciding factor is. If you are accused of it, then yes, you're guilty in this judge's eye, and you go to prison forever, Megan. That's what's going to happen now.
I mean, OMG. I don't even know what to say. I don't know what to say to this. I can't even wrap my head around it because it's so damn stupid.
Well, especially since Jeremy, literally every time she's mentioned, says, "Do not contact her. Don't just avoid these people."
Yeah.
Every time.
I think I found turtles. The
I
hell
was
are
going to
these?
say, I thought they had turtles. You could make a turtle out of that.
I like put a shell on top of it, like
Yeah.
the shell fit on it. Look at this. Let's see. No, this is not the wrong kind of lid. All right, I'll find the right kind of lid. I have the right kind of lid, I think, but I think I found something I could make a turtle out of. Yeah,
Jeremy,
look.
to be clear, from the very beginning, I've said no one contact her. She even wrote in the petition that I state no one contact her.
Well, so then how can you be accused of causing someone to contact her when it's so nebulous, when she's claiming to the judge that all these people are 100 people? We just drove down the streets of Otter Creek, and there was, like, in the middle of the day on Google, there was nobody there. When the Google car went down, there wasn't a soul in sight. I think we saw 3 people that day. She says there are hundreds of cars going by her house every day videotaping.
No,
does she have evidence of that? I mean, how does he's just taking her word for it that this stuff is happening to her because of you, and he's taking her word for it. I think that causing to be communicated thing is a real problem because I think it's too vague. I want to know what the definition of causing to be communicated is.
Well,
Because
he's not expanding on that by any means. He's not going into what causation actually looks like, and I think that's probably intentional. I think that's so he can use it later to smack Jeremy.
all right, we got to get going. I think my kids are home.
Your Honor.
So I'm not, Ms. Preston, I'm not denying you opportunity to be heard. I want to hear from you before,
Okay.
I want to get through their version since it's their motion. So, to the extent that you could follow, on December 29, the second DCA ruled on a case which
I understood everything you said.
affects potentially the language that this court added to the Supreme Court approved language that was already in effect. My intent was to not infringe on his constitutional rights. The argument is being made to the extent that I intended so. It may not have come to pass that way because this decision now says with similar language in that case that it was too broad, and it remanded it back, saying to the trial court, come up with different language that's more narrowly tailored to not infringe on such rights. And
Didn't he already say this?
they're
We already
asking the
read
court
the
to do
narrow
so by
language.
adding language that would now limit. So it says, right now it reads, you can't post anything about Ms. Preston or her kid.
Thank
Very
you.
broad. And what they're
Too
asking
broad.
is that it says.
Very broad.
Too broad.
He wants
Oh,
to
who wrote that?
extent-
Who wrote that very broad judgment? Who wrote that very broad injunction? It's very broad, he says, like he had nothing to do with it. He's the one who wrote it.
He's
Yeah,
naked.
he's mansplaining. He cannot shut up. He has said the same thing over and over again. He just can't admit I was wrong.
bully me, belittle me, humiliate me.
Oh,
and
shut
make
up,
money
Lynette.
off of me. And that's what he's doing. And in turn,
And he's letting her do this. He's belittling me. He's making money on me. Lynette, you could be making money too. I suggest you go get t-shirts that say shit shack on them. with a broken down picture of your shit shack and sell them online. You will make a fortune. You just don't know how to monetize this, but you could make money on it too.
his fans on their groups, which I do not have, but they do, says, let's kidnap her child. Let's Baker Act them so that then we should be able to get their child taken away.
Who said that? And you know what? Listen, if some kidnap, I doubt anybody said that.
I doubt that.
I'm sure a lot of people were like, why hasn't social services done something here? That a lot of people probably have that opinion. But why is he letting her just ramble on in the middle of his discussion with the other lawyer about the tailoring of the language? What does she have to say about this? Shut up, Lynette. You're not a lawyer. You have no idea what the law is, and you need to be quiet in court. And why is he allowing this to happen? And yes, his counsel should have objected. He should be jumping in there and saying, I object to her butting in to this conversation she is not involved in.
All of this is coming from everything he
So if he
says.
did that, and I'm not ruling on it because it's not an issue before the court, but it's more likely than not that if the posts were in the future about inciting others to commit acts of violence against you or your child, which kidnapping would be considered a
Oh,
felony,
kidnapping.
violent
It's
felony.
not.
Very likely that would not be constitutionally protected. That would be constitutionally unprotected as being construed as fighting words.
But you have no evidence that that's what was said.
Considered
Just her
personally
word.
abusive epithets, which, when considered or addressed by the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. So Mr. Hales would still be precluded and admonished and proscribed and enjoined.
Oh,
from
he
saying
loves
such
these
things.
words.
Then let me ask the courts, what are you then going to give him permission to post on his YouTube about me?
I'm not giving him permission to do anything. I'm denying him permission to do certain things within the parameters of what the Constitution allows.
And what, so what
So
does,
let me, I'll
Mind you,
paraphrase
10
it.
minutes
I don't
ago,
know
she
the
just said she
word.
understood
I could-
everything
I
the
could
judge
list
said.
for you
Right.
in the next 2 minutes, probably 15 cases. You guys are neighbors to a great extent. I know we got an Ohio connection, whatever, but what came out in evidence is he's a neighbor of yours by virtue of his property, because I had to address, yeah, but while you got to drive around the other way, even though your properties are closer.
And they
if you go-
don't.
So, you're neighbors. There are a dozen or more cases that say, for whatever reason, the injunctive process is not designed to keep people from being uncivil
Right.
and to prevent people
That's
from
for a
being
defamation
rude,
case
from
in civil
keeping
court.
people from being
So why are you doing this?
unnecessarily and unwanted boorish behavior towards another citizen who happens to be their
Right.
neighbor. There's not a good solution for that, not in injunctive court. There may be in another civil proceeding.
This
but
does
in
not really
injunctive
look like a
court.
turtle.
It's all about
It's-
violence.
I need
Right.
a smaller. It looks like an air filter.
Would provoke violence when addressed by the ordinary citizen as a matter of common knowledge, inherently likely to provoke violent reaction.
Looks like a turtle that spent too much time in that green water is what it looks like.
Under the
Court's
court.
intent would be to prescribe and prevent and to enjoin him from certain things, but I'm not gonna tell him, his lawyer might give him advice. I don't give advice of what people can do.
Every time they film us, every
Shut
single time they
up.
come up to us.
You are not
us
testifying,
not
and he's
going to
letting
them.
her. Jeremy hasn't been able to say one damn word in his own defense, not one, and she can continue to just tell lies. These are lies. She has no evidence of any of this, none. We can show proof that the things that she is saying, Jeremy has said the opposite. We can show that. So if she could show the judge that these things happened, then she would, but she isn't. It's just all words.
Coming to us, filming us.
Where's
Like
your
John
video of that?
walking on a walker,
Right?
down the road. No one's around. We got a neighbor
Why isn't Randy objecting?
we're talking to. I'm on the phone with an advocate. He drives up.
He might just be
screaming, 10
wanting her
feet,
to
10 feet.
display
You're
her
violating the 10
insanity.
feet. See people, he's violating it.
The more
He's turned
worked up
it
she
into
gets, the crazier
Ohio.
she gets.
Oh God.
And now we are facing charges of contempt of court for things we are not doing.
Give me 1 minute.
Giving him the ability to do that.
I cannot believe he's allowing her to keep doing this.
So here, hold that thought. I'm gonna just take a brief recess. If you guys need a comfort break, we're at 10:49. We've been going
Yeah,
since
I need
9.
to change a diaper.
All right,
Oh,
let's take-
bingo!
let's take 15
Change a
minutes.
diaper.
Isn't this
Her-
kid like 4?
Her kid, yeah, she's 4, and she's been sitting in the car all of this time. So that's the end of part 1 of hearing 3. There's another part which we are obviously not going to get to today. No, we will not get to that today. God. This is unbelievable. All right, we're gonna get to the super chats, and then I gotta go make Hangry a snack because he's hangry. And he's home, and he wants his egg sandwich. Callie Sandy RN, thanks for the super chat, says Megan can't find Valhalla's channel. Could you pass this to Valhalla for a Lego spin? Yours is coming next, so I get to you. I owe you $10.
Put it on my
the-
tab.
I will on the. I dropped his link in the chat.
I'll
But
do it.
Valhalla, you're a mod.
I'm doing it
You
right
can
now.
do that.
I
Yeah,
got
go
it.
drop your links. Drop your links, please.
I'm gonna put them in the chat, yo.
And let's see. Callie Sandy RN says, love you, Megan. Thank you so much, Callie Sandy. Appreciate you. Connie B, thanks for the super chat, says the judge is spending Jeremy's money. The district is not happy about the state's investigation into the former mayor at Jeremy's behest. Can of worms. Yeah. Did everybody in here like the stream, by the way? Like the stream. If you haven't liked it already, do it now. Kelly Breidenbaugh, thanks for the super chat, says, oh, just wait. Her lawyer's paralegal sat right behind Jeremy's table in the last court hearing. The paralegal was also at Feather's hearing, too.
It's just
Her-
grimy.
Who's paralegal? Oh, Lynette's
The new lawyer.
sat
for
behind Jeremy's table.
it. Yeah,
I wonder if she was listening in.
of course she was. She was trying to.
Patriot for Life, Meemaw, thanks for the super chat, says attorney is setting precedents for future cases in which he's going to let this judge walk all over himself and Jeremy. Well, I will say that in hearing number 5, Randy stands up for himself. Randy gives it back to the judge and tells him, I want to be heard without being interrupted. And that puts the judge back on his heels. And everybody's going to stand up and cheer when I play that.
Good.
So we're still on hearing number 3 though tomorrow. Before we get to 5, we're still on 3, and then we got to do 4, and then we'll get to 5.
I'm going to put MG's link in the chat right now as well, y'all. Go give him a sub.
Yeah, make sure you watch him tonight. He's going to read that new lawsuit. I can't wait to hear that. Mimi Two Boys, thanks for the super chat, says Larry needs to walk into that courtroom with a big buckle and a feather in his suit coat pocket. That would be hilarious. Kathy McClure, thanks for the super chat, says LOL. When we burn the trash, we can cook over it. Oh my God, you guys are too funny. I really think that the shit shack is coming along nicely. Robert Henderson, thanks to the super chat, says you need to spray it with that fart spray. Helen Gall, thanks to the super chat, says I fear for J&G's life after the email was given to him from the Levy County's deputies gave him. He wonders how they knew where he was. Well, isn't he always at the meetings though? That's a pretty good guess that he'll be at that monthly meeting. Legally Live, thanks to the super chat, says Preach Girl, so here for this. Marcus King, thanks for the super chat, says tell us how you really feel about it. Well, I feel like he's a hack. That's what I think. And this is still America, Judge, and I can call you a hack. I can call you a fake judge. I can call you presiding over a kangaroo court and family court. You know why? Because you don't get to tell me what to say. The Constitution of the United States protects my right to tell you, a government agent, what I think about you. I think you're shit. I think thank you. The Pocket Constitution guarantees that a judiciary is not above the people of the United States. The people of the United States are your boss. We are your supervisor. We are here to supervise you. And if we think that you're acting out of line, we're going to tell you about it. And I'm allowed to tell you about it. Come and stop me, Judge. Come and stop me. Stop me from talking about you. I would love to see you try. I would love to see you try. You're not going to do it. You can't. You're enjoined. You are, not me. You are. You're not allowed to restrain. You're not allowed to restrain my speech.
We have the armor of the U.S. Constitution, Your Honor.
It's absurd. Well, at least right now, maybe in another couple of years, the Supreme Court will agree with nutbags like this guy and be like, yeah, you know what? It's a good idea. We should definitely not allow anyone to criticize us. That's a great idea. Off to the gulag with you. But currently, we're still not under that regime. I don't know what to tell you, but you're doing it wrong.
We may not be far away from political dissidents being, summarily executed with rocket-propelled grenades or whatever the hell Kim Jong-un's doing over there. But we're not there yet. We're not there yet. And thank God for it. Juliet Morgan, thanks to the super chat, says, I don't know how the real mother is feeling about this. Well, I do. I know how the biological family is feeling about this, and it's not good. It's not good. And so everybody please say a prayer for them and pray for guidance on this situation and send your positive thoughts and energy towards them because they're going through a lot right now. It's really hard for them to watch this. And I've been made aware that they are watching it. And this is not something that they ever wanted for this child. So, please act with grace and wisdom. Don't do anything rash. Don't call anybody. Don't do anything. Let law enforcement take care of it if they will. And there's plenty of things going on behind the scenes that I promise you, there will be something. There will be more public attention through legal channels only. And we don't want to make anything worse for Jeremy. Nobody wants to make anything worse by, doing anything that this judge can construe as harassment of Lynette. Lynette is not being harassed, though. I need to remind everyone out there, and this judge included, that it is not harassment to speak publicly about someone's behavior in public. Bunny Mom, thanks for the super chat, says, but they can say Jeremy is a child rapist. Yeah, well, we don't know. He says that he has a handwriting expert. I think that it's in dispute whether or not she wrote those, but he says he can prove it. So, but he hasn't been allowed to in court. Stingy, thanks to the super chat, says, keep her name out your chat's mouth. Will Smith, that's funny. Beth Vals, thanks for the super sticker. I appreciate that. Apocrypha Darkbane, thanks to the super chat. All these months later, he has not gotten a chance to say his piece. That's right. No evidence presented on his side. Thanks for the super sticker, Carla. Appreciate that.
Reform Congress, thanks for the super chat. My donation towards the Shit Shack. I appreciate that. Thank you so much. Of course, the Shit Shack is just really made out of garbage, so it doesn't really cost anything. K-Matt Red Queen, thanks for the super chat, says, see Jeremy's message about the meeting. Oh, did he post another one on his channel? Kyle Alex gifted 5 Fox memberships. Thank you so much for your generosity. And to the 5 of you, welcome to the Fox Den. So happy to have you here. All right. If you are not following me at meganfox.locals.com, you need to be doing that, because that is when there is, you're going to find notifications to everything. When I'm going live, breaking news, that's where it will be. You'll get all the notifications. You don't have to pay anything. It's free to follow me. Just download the app on your phone. It's the Locals app. And then find me there, meganfox.locals.com. And then you'll get all the notifications. The only thing you can't do if you're not a paying member, which is only $5 a month, the only thing you won't be able to do is access exclusive content and participate in the live chat. And the live chat is so much fun. And that's where all the memes are. Speaking of the memes, that's what we do at the end of the show. We're going to go through the memes that Locals has been working really hard on, because you deserve it. You deserve to see these. Now, see that I can't show that. Dang it. That one I can't show. Okay. But Locals came up with a t-shirt idea for Lynette. There's just a lot of them. Remember the scummy C word? She said they called her a scummy C word. If she put that on a shirt, she could sell a ton. I'm telling you. I don't know why she doesn't. She should put it on a t-shirt, put up a website, and sell t-shirts, and people would buy them. All right. Here is Totera 4. What's Totera 4? What is this? What's Totera 4? I don't get it, but it looks like a Lego turtle. That looks like some good inspiration for me to try and make something with it, like a turtle with something growing on top of it. I think that's like pretty perfect. Let's see, what else do we have in here? We have wait, I have to read this first. The crack. No, I can't post that either. Dang
Locals,
it,
clean it up a little bit. We need YouTube friendly memes.
Locals, I cannot post potentially defamatory statements. Please, just keep it simple. Okay, apparently we are not going to end with Locals memes, because today Locals is feeling particularly spicy. So if you want to be a part of the meme farmers over there, you gotta sign up. It's $5 a month. It's fun. And the promo code right now is Tonsil Twins, all caps. Tonsil Twins, all caps. You'll get 2 free months when you sign up for a year, and you get 2 free months on me. Helen Gall, thanks for the super chat, says he went to Levy County meeting, not town hall meeting. Oh, well, what do I know? I don't know the difference between these things. Brenda Lanning Vaughn, thanks for the super chat, says my grandson makes stop motion Lego movies. He could help you make this into a feature film. I need to learn how to do that, because that sounds really fun. Bugs Adventure, thank you for becoming a member. Welcome to the Fox Den. If you're wondering what that horrible sound is, that's what foxes sound like. It's really weird. What does the fox say? It screams. It's weird. It's a really weird sound. All right. So what's coming up tonight? MG Law. He's going to be reading through the new lawsuit. The Hales have a new lawsuit against Lynette, and it looks like John Cook. And
me and Flux, I think, are going to do a stream around 7-ish tonight. Flux is awesome. She's another vet like I am, and we do a show occasionally called The Melting Point, where we just get together and bitch about whatever we want to bitch about and swap army stories, and it's a good time, y'all. It's fun.
Flux is super fun. I love her. She's my internet daughter, and
she's my girl.
I love her. So definitely support her and go over there and subscribe to her channel too. Tracy Fagan, thanks for the super chat, says Mega Pint. Appreciate you. Also, I have to find somewhere to redirect you. So let's see who's live right now. Redirect.
Broken Baker, potentially criminal, Danya, lead attorney, Brandy Churchwell, Veronica.
Why do I not see all these people?
I just refreshed mine.
Oh, well, so did I thought. That's weird. Okay, I see. Oh, there. Wait. I see Danya. I see. There she is. Okay. Where are we gonna go? What do you guys want to watch? Do you want to watch the Rust trial? Are you interested in the Rust trial? Because that's going on at Danya Direct's channel. Or the lawyer, he doesn't need a redirect. And you said Broken Baker is on too. I don't see him. What's the name?
He's on. He's doing the Tennessee versus Robin Howington day 3.
You know what? Today it's Broken Baker's turn. You guys haven't met him yet. So
Broken Baker is a good buddy of mine. We do a lot of streams together, and he's hilarious, y'all. When you get over there.
He is hilarious, and please tell him that I sent you and wish him my best, and please subscribe to his channel. There are a lot of criminally undersubscribed channels in the LawTube sphere that deserve your attention and your sub. Broken Baker is one of them. He is very interesting and very smart. So I highly recommend. All right, let me see. I got to catch up on. There's a couple new members. Let me get you in here under the gun. Reform Congress. Welcome to the Fox Den. I agree. We should reform Congress. And again, gifted 5 memberships. Nice. Congratulations to those of you who got it. And thank you so much for your generosity. I sure appreciate you. Baker is hilarious. Please tell him that I said hello. Fox Raid is beginning. And here we go.
Later, y'all.
Well, we would if I could find.
See, I timed.
Lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. Oh, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't want to say goodbye. No, I don't want to I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye.